All right. Well, welcome to the Margaret McLean Show. I'm your host, Margaret McLean, and I'm coming at you in New York City. My daughter just had twins, so I'm helping her out. But what I want to do is talk about the Harmony Montgomery case, which is very important. And I'm here with former Massachusetts juvenile judge, Carol Erskine. Welcome to the show, Carol.
Thank you. Great to be here. Thanks, Margaret.
Yeah, it's great to have you here. And we did a lot on the Karen Reed case together. So it's wonderful to have you in my studio. And again, this is not my normal background. I'm helping my daughter out. So
well, it's very nice, right?
Yeah, best I can do in New York City. And my mic is in a cup. So, hey, we improvise here. But anyway, if you like the show, guys, I'd appreciate it if you subscribe and press the like button. So just to give a little recap, on June 11th, 2026, the New Hampshire Supreme Court dealt a devastating blow in the Harmony Montgomery case. The court overturned Adam Montgomery's second-degree M conviction. And why is that? Because there was a fatal misstep by the trial court judge who improperly joined a July 2019 assault charge with the December 2019 M charge. So now the state of New Hampshire is back to square one. In its own ruling, the Supreme Court noted that the state's evidence proving Adam directly caused Harmony's death was comparatively weak on its own. And we're going to be talking about that. And they relied heavily for that particular M case on the shifting testimony of Kayla Montgomery, the estranged ex-wife of the defendant. So we're going to be talking about what happens next when the case is retried. Of course, the Attorney General's office is scrambling to salvage a case that's difficult to start with because the victim's body has never been found. What hurdles are they going to face now that these two cases are going to be severed? And of course, what we're going to also talk about is, as usual, the law and whether any evidence of prior bad acts can come in here. So welcome to the show once again. And let's start by talking about what do you see as happening next?
Well, I'm not sure what's going to happen next. I guess I'll start by saying I wasn't surprised by the decision. I had contacted Jameson's dads a few weeks before the decision came down just to tell them that I was concerned that they might reverse the murder conviction. I had actually written a blog about this on my Justice File website, saying that I did a 3-part blog called Deconstructing the Montgomery Appeal, and didn't really, in my view, see any errors with the issue of him being questioned at the car. You didn't really hear his voice, or Kayla Montgomery testifying, or any of the things other than the joinder issue. And of course, as you know, joinder can be tricky because you're asking a court to hear 2 different charges at the same time from 2 separate cases. And so there was the assault case, which the court actually upheld, said the evidence was very strong about that, because that was the majority of witnesses, right?
Right.
And then they overturned it on the second-degree conviction because they're saying the judge made a mistake by having the 2 cases heard together. I originally thought that was a mistake. And the reason I thought it was a mistake was because under the prior bad acts rule, she had basically already ruled that they could not bring in any of the long-term abuse that Harmony had suffered in that home, that the only abusive acts that could come in were in the days leading up to the final moment, leading up to her death. So that they had been evicted, they were living in a car. She allowed that, which was very limited, and there was really nothing wrong with that ruling, and I don't think the court saw there was anything wrong with it either. But then she allowed them to join the second-degree assault, which had occurred in July, long before they were in that car. And so it just, and this is, I think, one of the issues that I wrote about. I said, there's a conflict here where a judge says, we're not going to allow prior bad acts to come in because it's too prejudicial, right?
Right.
And then at the same time, but I'm going to join these two cases, and one of them is a serious prior bad act. It's a crime. It was a very severe assault. And that didn't make sense to me. I thought that ruling, they conflicted with each other. So I was worried about it, even though the judge made a significant indication that she was going to give a limiting instruction, and she gave a limiting instruction. And basically that limiting instruction would be, you have to consider the evidence of these two things separately. You can't consider them together. I mean, limiting instructions, I've given limiting instructions in sexual assault cases, and when you give a limiting instruction, you have to believe the jury's going to follow that. And I'd like to think juries do, but you don't know. And not only that, the Supreme Court of New Hampshire actually said the limiting instruction, I wonder if they would have overturned it if the limiting instruction had been better. But they said the limiting instruction just did not do enough to outweigh the prejudice that happened by the fact that the two cases were joined. So they honed right in on the limiting instruction, saying, the limiting instruction just was insufficient, which makes you wonder if it had been, more effective and something more than what the judge had said to the jury, whether this would have come out different. I think it's it's hard to guess, but I think the fact that the Supreme Court honed in on that, obviously was something that they were concerned about. And I think it's also worth noting that when you read the judge's decision, the trial court judge's initial decision on joinder, she said, I know this is a risk. So when you're going into it, you're a trial judge and you're saying, I know this is a risk, but I'm going to give a limiting instruction. You're kind of opening yourself up for appeal, and and for reversal, because that's what it was. So I wasn't surprised about this. I had written about it, but of course I was hopeful that they would say that essentially she did enough with the limiting instruction. Everything else was okay in terms of they didn't really make any ruling about Kayla Montgomery's testimony. I mean, that it was improper, but on the other hand, as you pointed out, it basically leaves the case a lot weaker without the evidence that he was, beating her and abusing her all along, which of course we know now is true. So that's where it stands.
So, I'm looking at the case from a prosecutor's lens and the retrial in particular here. Now, New Hampshire has a heavy, so there's a 3-prong legal test to get prior bad act evidence in. So I doubt that earlier case can come in, but let's take the testimony of course, this Kayla, who she was in jail for perjury. So right away, if you noticed in the last trial, they went through, you're in jail for perjury, and yep, she's admitting it. But I did think the prosecutor said, well, now you know what the consequences are, right? Because, if she lies again, she'll go to jail again for perjury. You think that's going to be effective the second time around?
Well, I think they did a good job with that. And of course, she's on parole and she's highly supervised. The worry is are they, will some, hopefully she's not. back into substances because she had been into substances for a long time. I mean, she was actually using substances when he got custody, and Massachusetts did nothing to test her, to bring her in. They didn't call her as a witness. So they basically sent Harmony with him and her, and she was using substances the whole time. She admits that. She admitted it on the stand. Remember, they asked you, have you ever been sober? And she said, I haven't, been sober and off drugs until I was incarcerated here. So that tells you, just yet another Massachusetts mistake, that they didn't do anything to vet her and sent Harmony essentially with a substance user, and sort of a long-term substance user. And then, of course, he was using substances very soon after they got there. So, is she a perfect witness? Of course not. From a prosecutorial standpoint, when you have to make a deal with the devil, that's just what you're going to have to deal with on cross-examination. Maybe I look at this differently than other people, but I thought her testimony was compelling, when she's describing, him, taking Harmony, just putting her in the shower to defrost her because he had her frozen, and she's testifying all of that. And, it's hard to believe that someone just is making this up. So, I mean, her testimony was so detailed, and it was corroborated by the evidence of where he hid the body, where they found DNA in the ceiling at the family shelter, and him taking, renting a U-Haul and taking her remains somewhere outside of Boston. I mean, all of her testimony was corroborated, but of course he admitted to doing all that. So this isn't a case where you say it's going to be hard because there's no body. Well, it is hard because you don't get the forensic evidence from that standpoint, but it's not hard from the standpoint of is there, is this an issue because there's no body, because he already admitted to it. He's already admitted to tampering with evidence and abuse of a corpse, and his position was, and he admitted, I did this, I did all these things to hide the remains and to abuse Harmony after her death. He's admitted to all that. So that's fair game. Yeah. And so then you have to believe he did all of these things, which are just so horrific and so horrendous, and did it because he wanted to hide the fact that Kayla did this, because she's the person that has no violent history. So his position, I'm assuming, will be the same, because what he has to combat now is really just mostly her testimony. So he's going to take the position that she's the one that did it. So, what the jury will know, that jury will know what happened to Harmony, and then it's going to be up to the jury to decide whether it was him or her. That's the way I'm looking at it.
Yeah, and then I was reviewing the New Hampshire Rule 404B, and I'd like to go over that because I think that some of the prior bad acts can come in definitely from the time that they were living in that car, the family, because if you look at the exceptions, right, so basically New Hampshire has a strict 3-pronged test. To get prior bad acts admitted in the upcoming trial, the state must prove the evidence is relevant for a specific non-character purpose.
Right.
So 1, you have proof of intent or state of mind. So the rule says prior acts can be admitted to show the defendant's specific mental state, malice, or intent, rather than a random accident. So the state could argue that the July 2019 assault on Harmony is admissible to prove Adam's ongoing hostility. What do you think about that?
Well, I think that's a very interesting theory. Whether they, obviously they got it all in under the Joinder ruling. Whether or not they could get it in under the rule, that rule it's so specific about intent and what can come in, and it can come in only under those restrictive requirements or mandates, as you pointed out, intent and state of mind and all of the things in the rule. So, but I mean, I think in the first trial, of course, they wanted to bring in a lot of the prior bad acts and didn't allow that. But of course,
Right.
they will, again, very likely it will, there will be an allowance of the same information that came in over those days in the car and what happened while they were in the car. I don't know if you remember, but they were being driven to the methadone clinic, and the woman who was the driver testified to her fear of him and her fear for Kayla. And you may remember they showed a picture of Kayla with a black eye and just a swollen face. And so you wonder if those things will come in if he's taking the position that she's the person who did it. It's hard to know how much they're going to be able to bring in under that rule, because it's so narrow.
It is narrow.
It's a very narrow rule.
And they can also, the state can introduce a prior bad act if it establishes why. So the defendant, why it establishes motive. So prosecutors could try to argue that Adam's history of physically abusing Harmony and hiding her from her mother created a powerful motive to silence her.
Yeah, that's a good point. I mean, they certainly did allow Crystal to testify, right? And so I don't see why that wouldn't come in this time, that he made every intent to hide her. I mean, it's when you're dealing with the narrow rules and strict rules of a trial, I'm sure it's frustrating, because what we know now is not only did he hide her from Crystal, he hid her from any mandated reporters. He never let her see a pediatrician. He didn't register her for school. He didn't make sure she was blind in one eye and legally blind. She had a disability, septo-optic dysplasia. So she had a neurologist, she had an endocrinologist in Massachusetts, an ophthalmologist. She was scheduled for eye surgery. He made sure none of that happened. He made sure that nobody saw that child who was a mandated reporter, other than, of course, the social worker who was assigned, who just happened to be his counselor when Adam was in DYS. So the social worker knew him, had a history with him. The grandmother called DCF and told DCF that the social worker has known Adam for 15 years. And so a lot of things that, there were a lot of chances for Harmony to be saved that didn't happen. And so, what comes in the trial is a totally different thing. But I will say, in terms of motive, one of the best witnesses was the woman who was one of his best friends. And she testified, if you remember, that he said to her, "I hate her to my very core. She reminds me of her mother." And I don't see why that's not going to come in.
I would imagine that could come in, because it does show motive. I think it's probative.
Yeah, I do too, and I don't think it's overly prejudicial. I mean, he made the statement. This is him talking to her. He wanted to tell her, why he had this hatred for Harmony, and just her testimony to me was really compelling. And just to have her, say he hated her to his very core. Those are his words. Yeah. So, but of course, what you're missing in all of this is Kevin Montgomery's testimony, of course, unless now all of a sudden the prior history comes in under 404. Now that, and the other thing is he's been convicted of it. So then you have that rule of prior, convictions are prejudicial and don't come in. So there are a lot of complicated evidentiary issues with this case. And so it's hard to know. I mean, without Kayla, of course, they have no case, pretty much no case. So yeah, it's worrisome.
Yeah, maybe it could also come in under, I'm trying to be creative like a prosecutor here, but evidence is admissible if it shows the current crime, which would be the second degree M, was part of a continuous interconnected sequence of events or an overarching plan.
Mm-hmm.
So the state could argue that the prior abuse was part of a
An
systematic
overarching
ongoing
plan, yeah,
pattern.
to abuse her, and
Mhm.
in one time that he abused her, and it was very similar with the punching in the head. It could, I mean, that's one possible avenue. But again, that, and so it falls under a different rule. So the question is whether or not they'll allow it as sort of a continuing event. Now, in joinder, you sort of have the same thing. Are they spatially connected? Were they similar in nature? There were the 5 Brown factors that the judge went through, and that was part of it. And yet it was because of them joining the two that the case was overturned. It's hard to say how much weight they put on, there wasn't really, I don't think, enough findings about that issue, about how connected they were, more so than it was about the limiting instructions. And so I go back to the whole issue of if the limiting instruction had been more effective, I don't know if we would be here. It's very hard to know because they don't say that, of course, but they certainly spent enough time on it.
Yeah. I don't know. I think I would have, it's easy to play Monday morning quarterback here, but I feel that the judge, like you said, thought it was a risk and is separate the two, but then use the rule and try to have all this, as much evidence come in as possible under that the rule here. Because I think
you make you make some really good points, because there are other avenues here to see whether or not that evidence can come in. I don't know if you saw this, and but WMUR issued a statement today saying that the AG's office is asking the New Hampshire Supreme Court to reconsider its decision. I didn't even know that was a thing.
They're not going to do that. Wasn't it unanimous? Was it?
Yeah. Yeah.
That's not going to happen.
Yeah, it's not going to happen.
And I missed that. I was taking care of
Well, I mean, I think
babies.
most people missed it. It just came across as a notification
Jeez.
for me. And I sent it was through WMUR. So I think, I don't think anyone really noticed it. And I don't think too many people are reporting on it because I don't see it happening. And I don't even know how that happens. How do you get a Supreme Court and a unanimous decision to say, hey, now, we didn't like your decision. Can you reconsider it? I mean, you can't blame the prosecutors for pushing joinder because their case was so much stronger when both cases, because
but then they saw that it was a risk too, that they'd have to try it again.
I know it was a risk. When I wrote the blogs on my website, I couldn't help honing in on that. And it had been a while. It had been over 7 months before they actually decided. It was actually almost 8 months. And kind of around the 6 or 7 month issue, I called Blair and Jonathan, dads of Harmony's brother, and I texted Blair and said, I'm concerned. And he said, why? And of course, I was concerned about the joinder argument. So people ask me if I agree with it. I guess what I say about it is I'm not surprised about it, because I can understand their reasoning, from a constitutional perspective. But, oftentimes limiting instructions are enough in cases where there's joinder to allow it and for it to be constitutionally valid. This just, in their view, wasn't the case.
So now do you think the trial judge is going to be extra cautious when the case is retried?
Well, it's a great question. When cases come back, and I've had that happen, when a case comes back and says, okay, you need to redo this case. I had one that came back on a very technical issue. And there wasn't even any statutory support under the law for the statute was silent about it, and came back on a technical issue. And yeah, I mean, you get the case back, and I think you just do your best, because you have lawyers are presenting things a little bit differently. Sometimes there are stipulations that are being made because what you see from the state's highest court is that they didn't have an issue with certain things. And so sometimes it makes it easier because you're like, well, the Supreme Court didn't have an issue with this. So, let's get a stipulation about this issue, because we already know that this wasn't an issue for them. So sometimes, there can be, certainly changes. And in this case, I'm sure, as the prosecutors, I think they're going to try to do everything they can. I don't know that it will be the same judge. I don't know that
okay.
it would be the same judge. I mean, sometimes it is, sometimes it isn't. I don't know if there's any particular rule in New Hampshire. I don't think that there is, but I would be surprised if it's the same judge, because they're going to file, as you just pointed out, those 404 motions again, prior bad acts, and she's already made rulings on those in the first trial. So then the question becomes, can she consider those things anew, given that the circumstances are different and what's before is different? And then you just sort of have the whole administrative aspect of it, where you have a chief justice who might say, I'm going to, assign this case to another judge. In the case where I got tipped, I was the first justice, so I did the judicial assignments, but I asked one of the associate justices to hear it, and I said, let's put a new set of eyes on this. And that's what we did. It's not It's not mandatory. There are some things that were mandatory, like if there was a ruling, for example, on someone registering as a sex offender, and then the law later changed saying if that person was a juvenile at the time, they don't have to register, the case would go back. It would have to be heard by the person that made the decision in the first place. So sometimes that has to happen, but I'm just not sure that it's going to be the same judge. So then, the things you're talking about, like the 404 rules and then prior bad acts, will be from a different judge.
Yeah, I almost think it makes sense to have a different judge for this one.
Yeah, I mean, I think there were so many pretrial rulings in this case. I mean, it's just like any other case that's, whether it's first or second degree, it's overwhelming in terms of the amount of pretrial motions, as you know, and judges are constantly having to deal with that. And I didn't do murder cases in the juvenile court, but we did everything else, any kind of, even manslaughter, which I don't know, we may have had one while I was there, but we did armed robberies and firearms cases and shootings that didn't result in a death. And so you kind of get used to, motions to suppress and, motions to dismiss based on the indictments and things like that if the juvenile was indicted. And it's a lot, you're just constantly deluged with motions.
Oh, gosh, yeah.
To write decisions. And so in this case, just following the docket as I did and reading all those motions, I mean, there were just a ton. And the other thing you'll have, of course, are the police officers will testify. And, so you'll have the same police officers, but of course, Kayla Montgomery, and I think the friend, and Kayla also. And I don't know if they'll bring the foster mom back. because there was the whole issue of Kayla saying it was because she had a wedding accident, a bathroom accident. They brought the foster mother in to say, no, she was fully trained. I mean, she was 4. She was 4 when he got custody. So,
well, somebody can be fully trained and then have so much stress in their lives that they revert back to, being
and that's
2 years
exactly what they pointed out during that. She, had a long time, had been trained the whole time, most of the time in the foster home. And the mother testified that to that too. So I think the implication was, she lived in fear. I can tell you she lived in fear because I know what happened in that home. I've read all the information in the civil case. There were 17 child abuse and neglect reports filed by family members who were in and out of the home, and the majority of them weren't even investigated. And the interesting thing is the assault case, where the department closed the case. That was in July that happened. They closed the case in October and said no finding of physical abuse. And then seven weeks later, she was dead in that car. So New Hampshire, terrible. A lot of problems in New Hampshire. So she can't get a break in New Hampshire at all. I mean, everything that happened to her and didn't happen to her is just horrific. And now the Supreme Court makes this decision. So you can imagine what it's like for, Blair and Jonathan, with their 3 boys, and Jameson, and having to go through it again.
Oh yeah.
Rough.
Awful.
Very tough.
Yeah, I can't imagine. Now, what do you think he'll change his defense strategy? Show up for the trial?
I don't know what his defense strategy will be, because I don't think he can change. I don't think he can. I think the initial strategy was there was no body, and then just before trial, they knew that wasn't going to work. And so they then took the position where he was going to admit to hiding her remains, abuse of a corpse, all of that. And now he's convicted of it, but he has made that admission. So I don't know what he's left with. What he's left with is it was Kayla, because we are in a position where we know that that Harmony is not alive. So I don't know what other position he can take other than that he did those things, to protect Kayla, which is interesting coming from a wife beater. It's like, oh, I just wanted to protect her from going to jail.
Yeah, I know. Do you think he would take, I think I know the answer, but I don't know. Do you think he'd take the stand the second time around?
Never. Yeah. Although I can't even imagine, because if he took the stand after admitting that he hid her remains, then he'd have to answer the question of what happened to her remains, right?
That's right.
That's why I think he won't take the stand. I think given that he's, the narcissistic, personality that he is, and a bully and an intimidating coward that he is, I think, he didn't even show up for the first trial.
No, exactly.
So, the first question is he even going to show up?
Yeah, is he going to show up?
That's number one. Yeah. And then number 2 is, will he testify to sort of counteract Kayla? But if he does that, he's already admitted to abusing Harmony after her death. So he's already admitted that she's not alive. So he takes the stand. He's got to say what happened to her. I can't see him doing that.
I can't see him doing that either, unless he took the stand and pointed the finger at Kayla and said, I don't know what Kayla did with her. Yeah, she did it. I panicked and I moved the body. I abused the corpse. If he came up with some excuse, but
yeah, I think it would be hard based on his conviction and based on his admission. I think it would be hard.
I agree.
I mean, I think if there's any positive by this, his appeal on the firearms case was upheld. And so he's serving 33 years. And because he was classified as a career criminal, he's not eligible for parole on the 33 years. And then he has an additional 11 years for the second degree assault, which was upheld. for punching Harmony in the head, and for the witness, tampering with the witness and abuse of a corpse. They got 11 years. So that's a total of 11 years, so 44 years he has
How
to
old is
serve.
he?
He's 36, but he has served what, pre-trial? Maybe he has served maybe 4 years pre-trial and awaiting during the appeal. So I think he's 36. And so if he has 44 years and it's down to 40, the earliest he could get out, because he wouldn't be paroled, because the 33 years would have to be served, but he could be paroled on the 11-year sentence. So it seems to me the earliest that he's going to be anywhere is in his 70s.
Good. And maybe who knows if he'll survive that long in prison. I would think he'd be a target.
Well, I think a lot of people have said that, right? I mean, I think you see a lot of people writing about that, saying maybe there should be some kind of, prison justice. But, at this point, we want, obviously, if that happened, let's say he died in prison during this, there would never be a record that he was convicted.
Right.
Of it. So I think, that's what happens when people die in prison awaiting an appeal or something like that. Then the charge just goes away. So I don't know.
And that happened in the Hernandez case.
Right.
Remember?
Right. It's just gone.
Yeah.
Yeah.
So maybe the prisoners know that. I don't know.
Yeah.
And they're waiting. No, that's terrible. But so I wonder if they had him in segregation.
Oh, I think so. He was actually moved out of New Hampshire. They couldn't contain him for some reason.
Okay.
Even the New Hampshire state system, and he was moved to a prison in, my understanding is in either Virginia or North Carolina. I can't remember what state, but a more southern state. He was moved to another facility, and I don't even know if it was a facility that's a federal facility, because the state facility couldn't manage him. I don't know if they couldn't manage him or whether or not he was unsafe around.
Probably unsafe. He's got to be those types in prison. The child abusers are not, they're the worst of the worst.
Right.
Yeah.
And he is a convicted child abuser now, And so, so I think, there were, it's a case that, had so much national attention because it started with Harmony being missing in 2021. I mean, she was, the death occurred in 2019. So, and then of course it came on New Year's Eve. It was, the police were out there saying no one has seen her for 2 years. She's missing. That was the call that Blair and Jonathan got on New Year's Eve.
Oh my gosh.
And then called me saying Harmony's missing, because Jameson, even though he was quite young at the time, he was 3, was asking for Harmony all the time. I mean, at times they were with the mother or in foster care together, and they had this very close relationship. And they would tell me stories of, like, the doorbell would ring and he would say, is that Harmony coming to visit? Or he would chase a little girl in the park with blonde hair and say, I think that's Harmony. So
that's so sad. Too bad she wasn't placed with them.
Well, the father got custody in February of 2019. Jameson was placed with them after that, I think in May or June. And then 6 months after that, there was a stipulation to a termination of parental rights. Montgomery's not the father of Jameson. There was another father, unnamed.
Oh, right. Okay.
And his rights were terminated. Just whoever he is, there's a termination entered. And the mom agreed to an open adoption after she met Blair and Jonathan. And that was in Boston. And then they asked for permission for me to finalize the adoption, the formal adoption. in November on National Adoption Day. And so we got permission to do that. So that was a really nice thing.
Yeah.
But of course, what we found out so much later was that that was in late November, 3 weeks later. That's when that's when Harmony died in that car. We didn't find that out, of course, until years later.
So sad.
Yeah.
Any more books, Carol, on the horizon?
Well, I just published my second children's book.
Wow, I'll have to buy it for the grandkids.
Yeah.
I can't believe I'm saying that.
They're age. I'll send you copies. I wrote the first book. It's called The Scary Cloud Monster, and it's a story. I wrote these stories for my kids when they were little. They were like 5, and they would say, "Well, tell it. We want a book with a scary story." Well, there are no books scary story for 5-year-olds,
right?
And so I wrote these books, and my daughter-in-law, who's one of the most amazing graphic artists and illustrators.
Oh my
ever.
gosh. That's
and
awesome.
She illustrated it by hand. It's really incredible. And so we did Cloud Monster first, and basically it's really about it's I have my own small like publishing company called Kid Hero Books, and it's called The Scary Cloud Monster, a kid hero story. And in these stories, the kids are always the heroes. They figure out, like, using their knowledge from like kindergarten and first grade of, this scary cloud monster appears, and they figure out, and it grabs one of the kids, and they figure out from school that if you put water in a cloud, it will rain out, and that's how they take care of the monster. And it has a little science experiment for kids to make it rain. But I wrote that while I was on the bench, and then I would just get copies from our printer. And then if I had to put a kid in foster care in that age range, I would give them the book, because it's about like overcoming your fears and empowering kids. And so my second book is just out. It's called The Scary Snow Monster.
Ooh.
And so, and we'll get a third book out at some point, but yeah, and I'm just busy teaching. I've been teaching criminal justice ethics and con law for the last 5 years at a college. I'm starting at a new college in 2 weeks. And teaching mostly in a master's program, teaching mostly police officers who want to further their education.
That's great.
And I work for the Municipal Police Institute doing domestic violence trainings and juvenile trainings for police. So it's pretty busy, but I try to really be out there and in the public on some cases that resonate with me. I'll be out there on Harmony's case, of course.
Yeah. Are you following Lindsay Clancy?
Very closely.
Yeah, me too.
Yeah, I've already been asked by a couple of local Boston news stations to do some trial analysis on that. One of the reasons I actually wrote an op-ed 3 years ago. It was published after she was arrested. I wrote an op-ed on the Clancy case, basically writing about the fact that for so long in my court, I had to deal with people, either parents who were on antipsychotic meds, or I had to do hundreds of cases of children who were on antipsychotic meds because DCF cannot consent to it. So a judge has to issue an order. So and before I was a judge, I represented 2 hospitals doing all of their antipsychotic med and commitment cases in court. And so I have a very, very strong familiarity with this stuff and background. And my op-ed piece was about the fact that these meds, over the 4-month period, she was on 13 different meds, and they kept changing them. So I wrote this I wrote this op-ed saying, that the Clancy case, had the same kind of issues that I had seen as a judge, and that is that the side effects to these drugs, especially when you're using them, as we used to call it, a medication cocktail, have very powerful effects, and people can become psychotic, and the effects are just horrific, and they were on kids too. So I have a strong background. I've been posting about that a lot about that
Yes.
today. And yeah, so so I will be doing some trial
Yeah.
analysis on that case. I think the one question that bothers me, I mean, her treatment was very disjointed. It was in different hospitals, different providers. One minute she's on Ativan and Valium at the same time. Sometimes she's on Lamictal and Seroquel at the same time, both antipsychotics,
Oh,
both,
yeah.
massive side effects, and is a very disorganized way of treatment. And according to her civil lawsuit, she was telling people, I'm having hallucinations. She's telling her husband, something's telling me to hurt the kids. So, as you know, she's going to admit to killing them, but she's doing a lack of criminal responsibility.
Right.
And as you know, I'm sure it's up to the prosecutor to prove that she wasn't insane. It doesn't, the burden of proof in Massachusetts is on the prosecutor. So, yeah, I just posted on X today a link to the civil suit, which really gives you a lot of information about just where they're going to go in the criminal case. But what a sad case, isn't it?
Oh, it's so sad. And I have I have a very close friend that's also severely mentally ill. And so I am actually familiar with all these different drugs and cocktails and
Yep.
the struggles that people have. And I also, I polled some of my friends, some of my girlfriends actually, said, what would you do with a case like this? And gave them both sides. And I asked, there must have been maybe like 12 or 13 of them. And I said, which one of you could find her guilty, like could convict? And not one of them raised a hand.
I think a lot of people are going to feel that way.
Yeah.
The question is, if she's admitting to the killings, as he has said she will there be enough evidence to say that she couldn't, meet the requirements or the tenets of the law, that she, because of the mental illness and because she was psychotic at the time, she's not criminally responsible because she couldn't, understand that it was basically wrong, is a simple way of putting the criminal responsibility. Not only that it wasn't wrong, but that she couldn't meet the requirements of the law or the tenets of the law. And that's going to be her argument. A lot of people say, the defense, the prosecutor takes the position that this was planned, that she had done some Google searches again. And they're also going to say that after she was, she had jumped out the window and she's in the intensive care unit, she's intubated, and writes a message saying, do I need a lawyer? They're going to use that. They're going, as if that in and of itself somehow, makes it clear that somehow she had premeditated this. It just
is that admissible?
I'm pretty sure they're going to. I mean, it's something that she did right after, right after the children were found deceased. So I think, and it's her statement, so it's not hearsay. So I'm pretty sure that's going to be admissible. But if you
wait a minute, wouldn't that fall under attorney-client privilege? Like you asked,
but she wasn't saying it to an attorney. I think she said it to her husband. Do I need an attorney?
Yeah, I know, but okay. It's still, though, you have a right to an attorney or to get an attorney. I don't know. But you're the judge, so you would.
Well, I mean, she's writing, do I need an attorney? I mean, I think, I don't know if it was to her husband, it certainly wasn't to a lawyer, because
Yeah.
she's saying, do I need an attorney? So there's no privilege there. But
Yeah. You're right.
I certainly don't think that comes anywhere close to being dispositive of the fact
No.
that, she was lucid, because people with mental illnesses, which I'm sure because you're a lawyer, many of them have lucid moments. It's not like when someone's psychotic, they're, just hallucinating and completely floridly psychotic every minute of every day.
Oh,
And
yeah. It goes in
so
and out.
she's going to have,
Yeah.
in the civil suit, they already have experts lined up.
Right.
And one of those experts I am familiar with from a case where he testified. And so he was a pretty, pretty strong expert witness. And I think she's got 2 or 3 experts that are going to testify that, hospitals and doctors and providers were clearly missing the signs that she was psychotic. I think one of the issues that has come up is that they had her on Seroquel, which is a very powerful antipsychotic. And when they put her on it, and I think in December, she then asked to be admitted to McLean's hospital because it was wreaking havoc with her. She was having symptoms and suicidal ideation, and it was all there. And so I think they're going to present the case that the use of Seroquel was causing these issues, and they weren't noticing it. And then they started to reduce it. According to what I read, they were reducing it rapidly, which is a dangerous thing to do with Seroquel.
Yeah.
And so I don't know how true that is, but it's somewhere in the papers. So we'll see. It's going to be an interesting case, right? So I'm glad we can cover it.
Oh, yes. I'll be covering it. Maybe we'll be on the same panel. I'm going to be covering it for NBC. It's funny. They just reached out the other day.
Yeah.
So I did a lot of
reached out to me also.
Oh, good.
Yeah, 10.
I'll have to ask the producer to put us on at the same time. Of course.
I just got their message a couple of days ago.
Yeah.
Good. And I sent them my op-ed. I said, I just want to send this to you ahead of time, so because I had this view. If you still want me to talk about it, I got a message back saying, no, this is the kind of stuff. So maybe we'll be on the same day.
Oh, that would be awesome. And I'll be covering it. Of course, so in July, that's the date that I'm here in New York for a month helping my daughter out. But I'm going to set up a whole studio in a different Airbnb with all the gadgets. So
great.
I'll be
back and
forth.
Maybe the same. Maybe we'll be on in the same panel.
That would be great.
Which would be great. Yeah. I mean, I think I'm sure I'll do a couple of the other podcasts that I've been doing lately, but it's hard to. I get asked to do. I was a judge for 20 years. It's like I got off the bench in 2023. I didn't even know this stuff existed.
Oh, the podcast stuff,
right?
It wasn't.
Completely clueless about that.
Well, it just became a big thing. So it's 26 now. So I think by the way, I podcasted way back prior to the Whitey trial, which was 2013. I was on a radio show and they podcasted all my things. And I didn't even know what one was. And so then I stopped doing that. And my son says, Mom, if you had kept it up, wow, you would be rich. I'm like, So, but yes. And I think after Karen Reed, a lot of people, really blew up as well. So,
I had no idea. And, so, I mean, technically I'm still pretty new to this. I think the first one, I did the very first one that I think I did one with Jen Coffindaffer, but I think the first one that I did was Lawyer.
That's great.
One that I did on Reed. And that just had,
that's huge.
That had something like 200,000 views. I mean, I was like stunned. I'm like, really? People,
well, he got in at the right time.
These things. It was crazy for me.
Yeah. So he got in at the right time, but he's also very good at what he does. And he's got this huge chat and all that. So, he's very good. That's great. Yeah. He is.
So, now just being busy, I try to be as selective as I can, because I can't, especially with the Montgomery thing, I just like that day, the Montgomery appeal came down and my phone was blowing up in the morning. I was getting calls from everybody to be on, but later in that day, I was officiating at my niece's wedding. So it was just a crazy day. So I did Boston
Congratulations.
25, I did
Yep.
NBC 10, I did
Yep.
WBZ, talked
Oh,
to
yeah.
Next Live, and then I shut my phone off after that.
Oh, yeah. No, that's wonderful.
But
Well,
thanks,
I appreciate,
Margaret. It's great.
I really appreciate you being on with me. I know how busy you are, so really appreciate it. And sorry for the little technical stuff in the beginning,
yeah,
but
no problem.
here I am trying to do it all, and I really wanted to cover this with you. So
Yeah, well, thank you so much. I was laughing about that because I said, I'm always the one that has the technical problems.
This
so
is the best, the coffee, the microwave and the coffee, the microphone and the
Yeah.
coffee cup. So, hey.
But thanks, Margaret. It's a pleasure.
Thank you. And
it's
I'll
good to see
end
you
this.
again.
Yes, and thank you so much. I'll end the stream and then stay on. I wanted to say a special goodbye, but thank you. A special goodbye to all of my listeners, and please subscribe, and we'll catch you next time. Good night.